so we can, again, use the time best we can. Chairman Watson, would you like to open us up in a word of prayer? It could be a slow one because we got to stall.
Slow prayer. Let's go to the Lord. Please, Lord, continue to look over us and guide us and give us your wisdom. Continue to protect us and look over us and keep us healthy, and continue to look over us in our travels. In Christ's name I pray. Amen.
Thank you. As soon as we get a quorum, I'm going to step down and present these first two bills, which I hope, I got to look at the sign-up sheet, hopefully won't be overly eventful for the audience. Not too bad. And then we will, based on the amount of time we have until 3 o'clock, we'll divide up our time for and against the remaining bill. Everyone that signed up on each side, we will not be able to get to everyone unless you don't speak very long at all, but we'll do a time block so we can hear from both sides equally on the bill, knowing that we have to stop by 3 o'clock. It's just the reality of this time of session for us. Appreciate your patience with us as we navigate everything we juggle up here. Senator Calvert, do you want to take over as chair? I'll step on down. As soon as we hit a quorum, we're getting close, then I can start presenting.
Appears we do now have a quorum, so I'll go ahead and yield to you, Chairman Strickland, to present Senate Bill 132.
Thank you,
Briefly.
Mr. Chairman. Members of the committee, I have with me Judge Gosselin from Hall County, this is what you call your circuit, Hall County Superior Court, who worked with the forensic, what's the name of your subcommittee?
The Forensic Subcommittee of the Behavioral Health Reform and Innovation Commission.
And as y'all know, this is a commission we passed several years ago that studies issues around mental health in Georgia, makes recommendations to us. From that committee, along with the help from DBHDD, we have Senate Bill 132. This deals with the issue of competency to face criminal charges. And I'll be brief and dive as deep as you want to get into it, but this is the issue where you have someone that a defense lawyer or the defendant themselves or prosecution or just the judge notices has an issue as to whether they're competent enough to even face their criminal charges. And we have a system currently in place where competency is evaluated by our department, and then you have, based on their finding, whether or not the case moves forward at that time, or whether there's additional time for restoration. The issue we have is we have a wait list. I don't have the updated numbers as of today, so I might fill you in on how many people are waiting currently to be evaluated. And you have people that are sitting in our jails in the custody of our state that are not able to face their criminal charges, but may actually be sitting in jail longer, and they would serve if they pled guilty to these charges. It's a big issue. It's a complicated issue. What this bill is doing is a couple different things, trying to simplify the process. First, you'll see in the bill that and I'm working off of LC, I should have done that first, 492240S. And you'll see the first thing we're dealing with is requiring a hearing initially when the issue of competency is raised with the court. And my friend here can fill you in on why that's important, but this puts the issue in front of the judge initially to see whether or not we need to have a defendant go through the process of the Department of Restoration. The second thing you'll see in the bill is the current law says that once someone is found initially to need to be evaluated, that the evaluation must happen within 90 days. We're carving out certain misdemeanor crimes. These are non-serious misdemeanor crimes, and saying they said 90-day clock, we're going to make it a 45-day clock, trying to make sure that we're expediting those cases in particular. Again, going back to the original issue of people sitting, waiting for evaluations longer, they would actually serve for a charge. And second, once you get past that 90-day to 45-day period, we go into the issue of what happens if they have to be restored. There's three options basically for the department to recommend for a judge. One is the person is mentally competent to face their charges. That's the recommendation. Two is they are not competent, but they can be restored, or 3, they're not competent, they can't be restored. And there's different paths. We're not addressing the laws, what happens after that. But looking at those that have to be restored, we're changing the time period. Currently, a court has jurisdiction for 9 months to consider the treatment of this individual. We're changing that to 120 days for the non-serious misdemeanors. That have that shorter clock. And then if they're not restored within that time period, we're having a provision where the case will be dismissed with these non-serious misdemeanors. An automatic dismissal with one catch. If the prosecutor objects and files a motion, says this is a case where it should not be dismissed, we should continue to hold them longer for restoration, then the court will consider that objection. Anything you want to add to it before we take questions? That was kind of a quick summary.
It was. I just wanted to tell you the process. The committee included Superior Court judges, state court judges, juvenile court judges, probate court judges, as well as prosecutors and one of the district attorneys here today, Herb Cranford, who was on the committee, and defense lawyers, as well as somebody from DBHDD. So there was a lot of input. We looked at this for a year. The process for restoration for somebody now can take a year while somebody's sitting in a local jail. And so we wanted to see if there were things we could do to streamline the process and to figure out if there were other alternatives. Sometimes if people can get medication in the jail, they don't have to go through this onerous process. But once they're in it, it's hard to pull back out. So that was the reason for the initial hearing. And I want to thank Senator Strickland for taking this on.
And one last thing I'll say, and we can open up for questions, Mr. Chairman, if you'd like. I've worked with our friends at Gactel that may have signed up to speak as well. They brought concerns to me about the initial hearing requirement and have expressed whether in current practice there's a role for the prosecution in that initial determination as whether someone is not competent, whether a hearing would let certain privileged information be put on the record that would not be proper. I've committed to them on working on some language in that section moving forward. I think that section may need some additional work. And so we met again today. We couldn't quite get the language right, but asked you to still move the bill and let us work on that moving forward as well.
I got a couple quick questions. One, this is described to us as people that are under arrest awaiting trial that are still incarcerated. Would it also apply to those that have been arrested and are out on bail?
Yes.
Okay. And my second question is, how about our resources to do these competency evaluations? Part of the problem now is we can't get to them a year. Is there any likelihood that we can get to them quicker?
Well, y'all have been good to Commissioner Tanner and given him some tools, and so things are looking better, and we've been trying other alternatives, and the department is doing other. So things for the evaluation piece have gotten a little better. The piece where the people need to go to the hospital to be restored is still really, really long. So thus the second part of the bill that Senator Strickland mentioned.
Other committee members have questions? Seems pretty clean and concise. So anybody signed up to testify here? I think I got a couple. Herb Cranford, my old buddy. Are you here, Herb?
Yes.
Come on up and let's hear what you got to say. Coweta County District Attorney.
Thank you, Senator. I co-sign everything that's already been said. Our committee, Chief Justice Boggs put me on it, and we talked about this for over a year. I do want to point out to kind of your question, as I recall, for felony cases, of the cases where a competency evaluation is ordered, DBHDD told us that 70+% of those come back as competent, like after the initial evaluation. So I think one thing this will help accomplish is, to the extent a judge can, and I think judges will be able to some extent, they're going to be able to assess whether on its face there's even support for incompetence. And I think, to the extent defense attorneys feel like they need to err on the side of filing these motions, having a judge look at it will, might give them some comfort as well. Yeah. So happy to take any other questions, but appreciate y'all's consideration.
Well, I figure if the defense attorneys and the prosecuting attorneys agree on this, we're probably everybody's rights are being protected, the public's and the accused, right?
Yeah. And I have spoken to Senator Strickland about trying to work with Gactel on addressing privilege. We certainly do not want to look at privileged information, but we want, particularly on behalf of victims, to be able to present to a judge evidence that may show the person is competent, that a judge might not otherwise have access to.
Any questions from committee members? All right. Thank you, Mr.
Thank you.
Cranford. Maisie Lynn Gurton and Carlos Rodriguez, Gactel.
Well, you guys have a lot going on. We don't want to be at all barriers. Thank you, Chairman. Maisie Lynn Gurton from the Georgia Association of Criminal Defense Lawyers. And as you heard, this is Carlos Rodriguez. He is a private practice practitioner out of Cobb County who has litigated quite a number of competency cases, so has more practice area expertise than I do on this issue. But we're really grateful to Chairman Strickland for the conversations that we've been able to have so far. We don't, unfortunately, yet, the sides don't yet all agree on this,
Okay.
Chairman. But we are diligently working to try to find some language that will balance the rights of the person who potentially needs the help and the state's resources and interest in helping serve that person.
You would agree that it does help the position of a defendant that has their competency questioned but sitting waiting for an evaluation?
We don't love having people sit. We would definitely love to see more funding and resources allocated to those processes of performing the evaluations and, when possible, helping restore our clients to competency.
But
or
this
treating-
shortens that from 9 months to 4 months, right, that they can sit without action?
Yeah, I mean, that part, on the misdemeanors it does.
Okay.
Not on the felonies.
All right.
The misdemeanor, the approach to misdemeanors in the bill is not something we have any concern about. Our concerns are all front-loaded in how the evaluation is initiated and whether or not privileged information has to be shared in order to trigger that evaluation occurring. And would you like to maybe outline, Carlos can outline probably with a little more artful language than I can for you.
Sure. So if you're looking at the bill, it's lines 18 through
We're
21.
walking off the original.
Oh, I'm sorry.
I think you're on 22 to 24 on our version, but I might be wrong.
Yes, lines 21 through 24. So as a practitioner that is frequently litigating competency, the judges want to get these cases in the queue with the department as quickly as possible, right? By requiring a hearing, it's only going to delay that. So that's one piece of the concern, is that best practices is that a defense attorney is going to bring to the court an ex parte motion for funds for an independent expert to evaluate and investigate the issues of competency. That in and of itself is going to be a bona fide doubt regarding the accused's mental competency. So what we're concerned about is if we're investigating our client's mental health and competency to stand trial and related issues, including insanity defenses, in an ex parte setting like AICI, right? That's the name of the case. So that is without the state. State's not involved in that process. But by bringing that to the court's attention, the current language, we're concerned, would then automatically impose this requirement for the state to be involved. And the concern is that that's going to be in conflict with some settled case law out of the Georgia Supreme Court, and that's the Putnell decision. And we certainly don't want efforts to expedite DBHDD's involvement to then compromise the integrity of potential convictions. And I certainly think that the district attorneys wouldn't want that either. But certainly we want to protect confidentiality and privilege, and are willing to work with the chairman, and certainly appreciate the invitation to be at the table, but want to protect the reality that the state isn't involved with competency only until a special plea is filed, a special plea of competency. And that's not done at the initial stage. That's only after a special plea is filed.
Okay. Are there questions from committee members? All right, well, that's all we had signed up. Thank y'all for sharing with us, and I'll receive any motion that the committee member deems appropriate. Got a motion to pass by Senator Watson. Is there a second? Second by Senator Still. Any discussion or proposed amendments to the legislation? All right then, all in favor of passage of LC 492240S, that's Senate Bill 132 substitute, raise your hand. All right, all opposed? Appears to be unanimous. Thank you, Mr. Chairman. We'll move on to SB 207.
All right, I think this one could be even a little bit quicker, despite the fact it's
Right.
90-something pages long. SB 207, working off of LC 492185. Oh, come on up, Lee. This is, with a couple exceptions, I'll tell you, the same bill we had last year. It was Senate Bill 157. Whenever you remember a bill number, it's kind of a bad sign. You probably worked too much on it. But this body passed this bill at least twice last year. This is occupational licensing boards and how they handle criminal records. You may recall 1 in 6 jobs in Georgia require an occupational license. The problem is every board, including our private boards, Secretary of State boards, all have different ways they deal with criminal records. And what we've seen and we heard last year in testimony I'm bringing before you today is individuals that, of course, businesses need workers, and people need lifted out of the criminal justice system and they want to work. The one thing we know that limits your chances of committing another crime is having a job. And so we know that we heard from individuals last year that simply don't go and seek employment because they can't even figure out how to get in certain industries. They can't figure out whether their past criminal records would disqualify them from working in certain industries. This bill has support of Georgia Chamber of Commerce, Metro Atlanta Chamber of Commerce, Faith and Freedom Coalition, Georgia Justice Project we worked on, plus others. Quickly, what the bill does is it confirms the type of crimes that boards will look at, which includes felonies and certain covered misdemeanors. It also makes certain that an offense, a previous offense, there's a direct relationship found between the criminal record and the license occupation. And the standard is if the licensure would pose a direct and substantial risk to public safety because they have not been rehabilitated to safely perform the duties and responsibilities of that board. In other words, you got to have a connection between what you're going to work in and what your past crimes were. There's a appeal process built in to have due process, standard of proof, findings of on the record through administrative process. You can have an appeal. That's all great, but it's also very important that there's now a predetermination process where someone can go in advance before they go and spend money and time training and education for a certain job to see whether or not they would qualify to work in a certain industry and get a certain license. We're also going to require our boards to have certain information on their websites that outline the process to be followed to work in that industry and also to deal with this process we have in this bill. Finally, we're going to collect public data now. We're going to have record reporting done to us that's public as to how criminal records are interacting with folks trying to work in certain industries. This bill included some cleanup when it comes to record restriction laws from last year. The only thing that's different between this bill and what you voted on last year was 3 additional cleanups. One that deals with an issue Senator from the 48th has also worked on with our human trafficking survivors. That there was an issue as to whether their petitions for vacature would be public record or under seal. We're making sure that's consistent now under seal. We're also clarifying one other issue we had in our record restriction laws, whether Department of Corrections records are also covered. We're including that. And finally, we are also including the information that a prosecutor's office has on past criminal records that have been sealed are not subject to our open records law. Those are the only cleanup we included. Everything else is a similar bill you voted on last year. Happy to dive deeper into it. This is a very, very important bill. This is something that was a top priority for the Senate last year. The House just passed it at about midnight, and we didn't have time to get it done. So I'd love to dive deeper if we want to, but I'm also trying to be respectful of everybody's time. Happy to take any questions.
Any questions for the author? I don't see any, and you have Mr. Askew there with you. You're the only person signed up to speak.
Say
so
amen.
Anything to add?
Amen. Thank you. Thank you.
Were there any changes from last year? As it
Just
seems?
those 3 things I
That's
noticed,
it.
those 3
Okay.
cleanups.
All right. I got another motion to pass by Senator Watson, second by Senator Parent. Any discussion or proposed amendments? All right, all in favor, raise your hand. And all opposed, same sign. All right, thank you. Again, passes unanimous. Very good.
All right. Want to keep doing it?
Now I'm going to turn it over to you now because I may have to sneak out a little bit early. Mine starts at 3. I may be the hard stop. So let me
Well,
get
left
out
us
of your
30
way.
minutes. I did the best I could. All right, Senator Setzler, are you here? Come on up. We're going to move on to Senate Bill 36. We are working off of LC 442920. Is that what you have?
Yes, sir. LC 442920 ER. Yes, sir.
All right, the floor is yours.
Thank you, Mr. Chairman, members of the committee. Bring before you today Senate Bill 36. I provided for you in your packets some things for you. I'll orient you to those so you can see those as is relevant. Going to make it just a short presentation. Glad to take questions. What I have for you today is I've got for you a map. This is the states in green that have RFRA level protections for free exercise of religion. You can see 38 states around the nation have this either by statute or by high court ruling. Another chart here talks about even within Georgia that our military bases, even felons in our prisons have access to full protection for free exercise under our framework. And of course, I've got a provision of the state constitution relevant to free exercise. And of course, I have the Religious Freedom Restoration Act, the federal law. This statute's for you in your folder if you want to look at that and reference that. And lastly, Mr. Chairman, I have this letter from 11 law professors from Georgetown, Princeton, Stanford, UVA, Notre Dame, Harvard Law, standing behind this as a solid approach, the appropriate approach to fully recognize constitutional rights to free exercise. In fact, it's authored by Doug Laycock from the University of Virginia Law School. He is widely recognized as the author of the federal RFRA, the 1993 bill, after which this language is specifically crafted. Again, every Georgian should be free to worship and exercise their faith without unfair federal, state, and local government intrusion. Senate Bill 36 protects ordinary people from unfair state and local government intrusion by exactly mirroring the bipartisan federal RFRA law that protects people from federal government intrusion. After the federal RFRA law was passed almost unanimously in 1993, the U.S. Supreme Court ruled in 97 that the federal RFRA only protects people from federal government intrusion and would not protect people from unfair state and local government actions. Since then, as I alluded to earlier, 38 of 50 states have adopted their own state RFRA laws or seen their high courts adopt RFRA protections by judicial ruling. Georgia passed a RFRA, or bill referred to as RFRA in 2016, that's language was dramatically different than the federal RFRA law. That was vetoed by Governor Nathan Deal. This language mirrors exactly the federal RFRA law. In 17, Mr. Chairman, our Attorney General confirmed that without a state RFRA law, Georgians do not have full religious protections, but rather have allowing state and local governments to infringe on people's faith for any, quote, rational basis. That's the lowest level of legal protection that exists in law. Since 2021, 7 states have passed state RFRA laws, and in 2024, Utah, Iowa, and Nebraska became the 36th, 37th, and 38th states to adopt state RFRA laws, many of these with near unanimous votes. The Wyoming House has passed RFRA by a vote of 57-3 this session. It's being debated today in the RFRA in the Wyoming Senate, expecting overwhelming support in Wyoming. Mr. Chairman, the bill before you, LC 442920, is the exact language that passed our Senate last year, with 2 small changes added at the request of our governor. On page 3, there's a provision that protects judges from legal action, so folks can't come after judges as a government entity. That's consistent with federal law. The governor's office, out of an abundance of caution, wanted to put that in statute again to make sure this mirrors federal law, not just in the language, but also in that process purpose. And the last page, this addition, although we don't have the ability to affect the federal establishment clause, we clarified for any reader that this has no effect on the establishment of religion. This actually was alluded to and asked for by the ACLU last year in this committee. I wouldn't forecast their support for this underlying bill, but this is a provision that we listened to in debate last year, and the governor's office asked us to include because it's, again, as an abundance of caution, clarifying for any reader, this does not have any effect on establishment of religion. And with that, Mr. Chairman, glad to take questions.
Any questions for the author? Senator Parent?
Thank you, Mr. Chairman. Thank you, Senator Setzler. Just two quick questions. Do you know how many states, I'm looking at your map that you briefly touched on. Do you know how many states in the country do not have a state-level civil rights law?
Yeah. I believe there's 3. Is 3 the right number?
You may actually know better than me, but that would have been my answer as well.
I believe there's 3.
And we're one of them. Am I correct?
Correct. So the framework in Georgia, for those who don't know, as we alluded to earlier, federal law protects our citizens' civil rights really from broadly and completely. Some states have mirrored that in state law, but because Georgia citizens have protections in federal law and are able to file, 1983 civil rights cases, and candidly have much procedurally, candidly better treatment in our federal courts, oftentimes they do in our state courts. We've not seen fit as a state to mirror that. As you know, from a RFRA perspective, the things the RFRA does, there is no federal protection for. The things the state civil rights law would propose are currently fully protected by federal law.
Yes, but, well, I don't actually totally agree with what you said, but isn't it the case that in some of these recent examples of states passing RFRA post-Obergefell, which is really when it became more popular for the states to do it, which for anyone that doesn't know is the Supreme Court case that legalized same-sex marriage, how many of the more recent ones have passed it in conjunction with passing a state civil rights law? Because that's been some of the concern, is that that we don't since we don't have a civil rights law, then there's more concern that it would impact people with private employment and public accommodation. And I know in Utah they moved them together, and so it was kind of a compromise. So curious how many did it that way. And
so, Senator, there haven't been any states that lacked a comprehensive state civil rights law that implemented a comprehensive law at the same time that they passed RFRA. In addition to that, maybe a further extension on the answer is that there are a number of states that have state civil rights laws that protect additional categories beyond what's found in at least public accommodation and education, other areas. Employment, obviously, at the federal level has been interpreted to include sexual orientation, gender identity, but some other areas of federal law have not. There are a variety of states that have RFRA laws that have those protections in their state anti-discrimination laws, and states that don't have them. So, an example, we've got 7 new RFRA states since 2021, and those include Montana, North Dakota, South Dakota, West Virginia, Nebraska. So those are 5 states that have what I would view as comprehensive civil rights laws, but they don't protect sexual orientation, gender identity. We also have Iowa and Utah, 2 new RFRA states that just last year passed RFRA that do have that kind of extra protection. There are a number of states that passed RFRA earlier that also have sexual orientation and gender identity provisions. So states like Illinois and Rhode Island and Virginia. There are others as well that have it by statute that we could talk about. And I think the point that I would make, and I don't want to go beyond the question you're asking, but I think what's interesting is that RFRA, from our perspective, has worked well in those different environments. So states with different kinds of civil rights protections, more expansive, less expansive. RFRA simply fits into whatever that underlying statutory scheme is, to make sure that where there's an instance where there's an allegation that some governmental action impedes, burdens a sincerely held religious belief, that the court applies strict scrutiny. And at the federal law and in these states that I've mentioned, that applies to all their laws, whether it's in the context of civil rights or some other area. And so we think that it's a
it's a great conversation to have. What should the nature and extent of civil rights laws be? But we think RFRA fits regardless of what the answer to that underlying question is.
Thank you. Can I ask one quick follow-up since you're on the Pembroke side?
Yeah.
Is
Go
it
ahead.
correct that in Utah, though, they had a civil rights statute already? Is that what you said?
I was going to speak to that.
Yeah.
One thing that's very interesting about this, and this is where we tried to be very neutral with this bill. In the Utah framework, you raised the question of sexual orientation, gender identity. In Utah's framework, that before RFRA was passed, there is a prohibition for any local ordinances that affect sexual orientation, gender identity. So local governments couldn't pass any local ordinance because state law specifically wiped those out. Okay. When RFRA passed last year unanimously in one of the chambers in Utah, the effect it had is a stronger religious protection than what we're proposing here. What we're proposing here, the local ordinances, any local discrimination ordinance is not wiped clean by this bill. It stays in place. This bill doesn't yield to it. It doesn't override it like Utah was. It would stand with it. And as we talked about this in the media, RFRA travels very well around Georgia. If you have a community that raises a local interest to protect a certain group, this bill doesn't change that. This bill simply allows an individual's right to be recognized fully, whereas in Utah, any local ability to do that was wiped clean by the prior law.
And maybe just a clarifying comment that 2015 Utah adopted a range of religious liberty protections and added sexual orientation and gender identity, did not add that, added it to employment, and added it to housing, did not add it to public accommodations, and then eliminated the ability of locals to pass any kind of law that was more expansive than state law. They then operated under that environment until this past year when they passed a RFRA. And so RFRA just slid into that existing kind of compromise that they reached on the other issue. But there wasn't a RFRA in exchange for civil rights extension compromise. RFRA came many, many years later after that was agreed to.
Yeah, it's all very complicated, and we could talk forever, and I appreciate it. I just wanted to have the committee aware that when they did that in Utah in 2015, they actually moved the RFRA plus protections and housing and employment for gay couples at the same time.
Correct. I just wanted to be clear for the committee as well. The effect, though, when RFRA passed was with respect to what's being proposed before the committee now, the religious interests in Utah are protected more strongly than what this bill proposes.
All right, let's do this. No more questions right now from the committee. Let's give each side 10 minutes total time. I'm going to start with those for it, and then I'll give 10 minutes for those against it, and I'll work off the sheet based on the order you signed up. And so we're going to start a clock, and when 10 minutes is up, we'll have to stop the testimony at that point. First up is Thomas Weaver. Go ahead and start the. Mr. Weaver.
Mr. Chairman. I fully support your colleagues' efforts to implement a RFRA version of federal law here in Georgia and approbation of the Rehnquist Court's holding in Bernie versus Flores. And I, with respect to time, I'll cease there.
Thank you. Appreciate you, Mr. Weaver. Next, Mike Griffin with the Georgia Baptists.
Thank you, Mr. Chairman and the committee. My name is Mike Griffin. I'm the Public Affairs Representative of the Georgia Baptist Mission Board, and we do support Senator Setzler and the passing of Religious Freedom Restoration Act. In 2014, and since I have represented Georgia Baptists is when I started, we've been for having a Religious Freedom Restoration Act. In 2014, we passed a resolution entitled Protecting Religious Liberty, and we have approximately 1.4 million Georgians, up to 3,500 churches. And just very briefly, the bottom line is that this just simply restores the original intent of the First Amendment related to religious freedom, and it puts it in line with the freedom of speech, freedom of press, freedom of assembly, and the freedom of the ability to appeal to the government. I want to close with a quote from Bill Clinton, who signed the federal RFRA into law in 1993. Here's what he said. He said, "But let us never believe that the freedom of religion imposes on any of us some responsibility to run from our convictions. Let us instead respect one another's faith, fight to the death to preserve the right of every American to practice whatever convictions he or she has, but bring our values back to the table of American discourse to heal our troubled land." And that's a quote from President Bill Clinton when he signed the 1993 RFRA. We would encourage the committee's favorable support, Mr. Chairman.
Thank you, Mr. Griffin.
Thank you.
Next, we have Paul Smith with Citizen Impact. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, members of the committee. I'll also be brief. I'm Executive Director of Citizen Impact. We're a network of churches and pastors all across Georgia. I should say churches and Christian schools, what I meant to say. We support the Religious Freedom Restoration Act because, as already been stated so effectively, it just restores free exercise of religion from being treated as a second-class right to the same rights as other First Amendment protections. And on behalf of our churches and Christian schools, we ask for support of that. I do think, if you don't mind me adding, that even some of our supporters, followers, have misunderstood the bill, that you just have to say it's against my religion and you win, but it just gives you a day in court to argue that, and we support that effort.
Thank you. The next, Chelsea Thompson with Frontline. Good afternoon.
Thank you, Chairman, members of the committee. So, as Chairman said, so my name is Chelsea Thompson. I'm General Counsel for Frontline, and we are in support of SB 36. The bill is simple. The Georgia RFRA would protect our citizens from illegitimate state and local government intrusion by mirroring the federal RFRA law. Many people, when asked, we had a panel recently at an event, and many people, when asked, they assume that their freedom of religion cannot be infringed on by the government according to the First Amendment. However, as Senator Setzler mentioned, the 1997 SCOTUS case limited the scope of RFRA to the federal government only. And so leaving our religious freedoms now in Georgia on the rational basis standard. And so we are one of very few states that do not have a RFRA, and we hope that Georgia can pass that this year and bring our religious freedoms of First Amendment up to a compelling state interest test. Thank you so much.
All right, thank you. All right, we're going to... On the other side, those that are opposed to the bill, we'll start with, is it Dunika Emulano? Was I close? Not quite, I'm sorry. Good afternoon.
Good afternoon, Chairman and members of the committee. My name is Nneka Ewulanu, and I am a staff attorney at the ACLU of Georgia. I'm here to testify in opposition to SB 36 because it opens the door to excessive litigation, harms marginalized groups, and pokes holes throughout Georgia code. While this bill may be called the Religious Freedom and Restoration Act, or RFRA, it's not about freedom of religion, it's about the freedom to discriminate. SB 36 would create expansive religious exemptions throughout Georgia code. The act would enable individuals, businesses, and corporations to challenge employment laws, non-discrimination laws, health and safety laws, and other neutral laws by arguing that they burden religion. This landscape was condemned by Justice Scalia, who warned about the prospect of religious exemptions from civic obligations. This bill would also open the floodgates for litigation against local cities, counties, and the state of Georgia at a time when Governor Kemp is actively pushing tort reform legislation aimed at reducing the state's legal liabilities. These risks are not hypothetical. There are cases across the country where RFRA has been invoked to avoid complying with local and state laws. In Indiana, a father charged with domestic abuse and strangulation of his child used RFRA as a defense, claiming that his religious beliefs required him to use corporal punishment. In Connecticut, a church invoked RFRA as a defense against allegations that the church retained an employee accused of sexually abusing a child. RFRA is not just used defensively, but offensively as well. In Texas, a ministry used their state's RFRA to argue that a health and safety ordinance that regulated food safety for feeding the homeless prevented them from carrying out their religious mission. After more than 6 years of litigation, which cost the city of Dallas more than $1 million in attorney's fees, the ministry prevailed. Finally, SB 36 jeopardizes the rights of minorities by inserting religious exemptions to non-discrimination ordinances. Across the country, RFRAs have repeatedly been invoked by individuals and businesses to deny services to the LGBTQ+ community. And make no mistake, the risk is not just to LGBTQ people. Religion could be cited to deny housing, healthcare, and equal pay to Black people, women, and interracial couples, and it historically has been. The ACLU has always been a steadfast champion for the First Amendment, including freedom of religion. But this bill does more harm than good. We urge you to vote no on SB 36.
All right, thank you. Next, we have Rabbi Michael Bernstein. Good afternoon.
Good afternoon. So I'll just say it like this. When Governor Nathan Deal vetoed the RFRA bill in 2016, he asked if Georgia was a welcoming state or one that had to discriminate against some to protect faith institutions. And as a rabbi, I really appreciated that, because as a religious minority, we don't have the luxury of some of my religious colleagues who are speaking for this bill of being able to know that some of the very basis of people's assumptions about whose religion someone is, it'll never be that it is a Jewish assumption. So how are we protected? By the First Amendment, but not just the free exercise clause, but the establishment clause. And really, that's what makes religion different than all of the other aspects of free exercise. There is an absolute need to make sure that no singular religion and what it believes is the law of the land or is enshrined in the law of the land. And for me, as has been said and as will be said, RFRA is about that discrimination. Every single person should be protected regardless of what they believe, but even more importantly, regardless of what people who hate them believe. And as a Jew, I take that very seriously. As much as we hate to use that language, people use this RFRA in bad faith all the time. And it may be your own religious belief, but just as Jews have learned, people can use their own religious belief to hate. And I would rather depend on the Constitution as the civil religion of this country than protect other people's right to use their religion to impinge on my rights. And of course, the rights of those who are going to speak, the people who are in most danger at this moment, people of the LGBTQ community and others who are so marginalized and who need protection themselves, not the protection of those who would hate them.
Thank you. Next, we have Pastor Arir.
Thank you, Mr. Chair. Members of the committee, good afternoon. I'm the Reverend Matthew Daniel Arir. I'm a theologian. I'm a husband. I'm a pastor of an inclusive Lutheran community here in Atlanta. More than that, I'm a native son of the great state of Georgia, a state that has long prided itself on faith, on fairness, on justice. SB 36 is an assault on those values. Dr. Martin Luther King Jr. said, "The arc of the moral universe is long, but it will bend towards justice." That arc does not bend on its own. It bends when people stand up to injustice, when power is used for good, and when fear does not rule the day. Senators, where will you be on that arc? Let's be very clear. Religious freedom is not under attack in Georgia. It's already protected by the Constitution and by the courts. What is under attack is the rights of everyday Georgians, workers and parents and families and children, to live free from government-sanctioned discrimination. SB 36 does not protect faith. It weaponizes it. We've seen it before. Faith was used in this state to justify segregation. Faith was used to deny women's rights. Faith was used to silence, exclude, and oppress. And now again, faith is being twisted into a tool for harm. Make no mistake, if this bill passes, people will suffer. People will lose access to housing, to health care, to dignity. Families will be denied services. Foster children will be left without homes, and yes, people will die. If you pass this bill, you are not defending faith. You are distorting it. You are writing discrimination into law. SB 36 is not the future Georgia deserves. Reject it. Stand for what is right. History will remember where you stood, and so will we. Thank you, Mr. Chair.
Thank you. We have 2 minutes and 45 seconds left. Reverend Dillard. Good afternoon.
Good afternoon. You just called out the time to a Baptist preacher. But
I know. Well, I just.
So I
it was
absolutely
good luck
throw
that I
my
guessed
phone
right.
away, Chairman. My goodness. I'll do the best I can. So I will get right to the point. The thing that I really want to implore to you, committee, thank you for your time, is that this is not a bill that will support us. I am also a Georgia native. I'm from Macon, Georgia. I went to school right here in Atlanta. I'm a Spelman College native. I'm a Spelman College graduate. I'm an Emory graduate. I'm a UGA graduate. I love this state. I love these people. I pastor these people. And what I am currently dealing with is congregants who are navigating IVF, who are navigating IUI, who are navigating maternal health challenges. And this bill is dangerous for that. Women are at risk. This bill is ambiguous. This bill will give people and embolden people the opportunity to turn people away, and women will die because of it. I will mind the time, but I am sure that it will cost us lives, and I know that Georgia is not the place that wants those lives or their blood on their name. Please do not allow this out of this committee. Thank you.
Thank you. All right, Mr. Jeff Graham, you might be closing us out. Come on up. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, members of the committee. I will keep it short. Thank you, Senator Parent, for your questions. I think that gets to the root of this. What happens if we do create a carve-out just for one group of people when we don't have a state civil rights law that protects all groups of people? These are the dangers that we're hearing about. This is why 18 municipalities have passed non-discrimination ordinances that do put people of faith along with other groups such as women, immigrants, veterans, and yes, members of the LGBT community on an even playing field when it comes to charges against discrimination. We all agree that protecting people of faith is critically important, but not at the expense of protecting all people who fear discrimination here in Georgia. Please hold and do not pass on Senate Bill 36. Thank you.
Thank you, Mr. Graham. All right. That concludes our public testimony section. There were still several others we were not able to get to, but thank you for being with us. We have a couple of amendments that have been handed out. I think the right posture would be first see if we have a motion from the committee first, and then we can consider the amendments. What's the pleasure of the committee? Leader Gooch.
Yeah. Are we working off of the original bill or the sub that was handed out?
No, we're working off of LC 442920.
ER? I'll make a motion to pass Senate Bill 36.
A motion from Leader Gooch, a second from Senator Calzert. Any discussion? All right, at this time, the only LC that we have to consider is the one that was noticed. However, we do have two amendments, and if the other substitute is offered by way of amendment, that would be the proper way of doing that. So we have any amendments? Yes. Leader Jones.
Mr. Chair, we do have one amendment. Yes. Well, the first amendment is LC 443106 ERS. And by starting off, I would actually go to, and I'll just be brief on this. I'd actually go to the end of the LC, which actually is pages 13 through 15. And so you'll see within this particular amendment that it actually does have a Georgia Religious Freedom Restoration Act. So there is actually a Georgia Freedom Restoration Act component to this. Then the question becomes, can it actually be attached to a larger anti-discrimination bill, which has been discussed, that we probably would need that. So first and foremost, this actually does carry a Georgia Religious Freedom Restoration part, which actually I believe is almost verbatim from what Senator Setzler has. Now the question becomes to make sure that there is no unintended consequences as far as discrimination is concerned. And the part that I will go to, so this amendment does two things. Number one, it creates a statewide anti-discrimination ban, which has been discussed. And then secondly, though, I would go to a part that might hopefully ease some concerns, and that would be page 11. And if you look at lines 243 through 249, it does actually create, on page 11, line 243 through 249, this particular amendment does still create an employer religious discrimination exception if reasonable accommodations can be made. So there actually is an exception made for employers on religious grounds if reasonable accommodation can actually be made. So this amendment does two things. Number one, it does actually create a Religious Freedom Restoration Act, but it also maintains that there is a religious exception, but it also creates the larger anti-discrimination ban as far as employment is concerned and also as far as housing is concerned. So we think that that actually balances the interests. One interest is to make sure that everyone's religion is respected, but at the same time make sure that no one is actually discriminated against. And we've done that by adding in this page 11, line 243 to 249, where we actually do give that exception for employers if they can have reasonable accommodation, which I think fits some of the recent case law. So with that, Mr. Chair, I'll just kind of be brief with it. I know it's a long amendment, but those are the things that I wanted to point out as far as the amendment was concerned.
And your amendment is basically to strike the entire bill and replace it with your substitute.
That's correct.
Which
yes,
we
sir.
discussed. You brought a substitute, but I think the proper way to do it would be an amendment like that. Is there a second for the amendment? We have an amendment explained with the second. I'll let the author respond.
Thank you, Mr. Chairman. Appreciate the discussion. I'd like to highlight the words of the minority leader himself. You know, we want no unintended consequences. If this committee were to take an amendment to have a comprehensive civil rights law imposed on the state of Georgia without multiple years of study, I think we're going to have unintended consequences. I think the RFRA bill we've got proposed before us here is tested language. It's tested nationally. It's tested in 38 states. And it's crafted in a way that's nested into Georgia law in a way that's not going to have unintended consequences. It fits in just as well-written RFRA laws do. I think a comprehensive move like this is not something we could or should do before this committee.
All right.
And lastly, Mr. Chairman, all the protections that are contemplated here are protected in federal law. We don't need a state statute to provide these protections.
Any further discussion on the amendment? Does everybody understand the amendment? All right, all those in favor of the amendment, please raise your hand. All right, 3, all opposed, like sign. Did you count? 7, amendment fails. Do we have any other amendments? Senator Parent.
Thank you, Chairman Strickland. Well, perhaps if to the author's view, if this is too comprehensive, I have a couple much shorter amendments that everyone should be in possession of that could also take the edge off a couple of the complicated issues with the author's legislation. Let's first look at AM 440208ER. This one, as was mentioned by one of
Which one are you looking at? I'm sorry, I was distracted.
440208ER.
8, okay.
Yes, this particular amendment, as testified to by Mr. Graham, there are 18 municipalities that have local non-discrimination statutes. And so all that this would do, this amendment, is not erase the protections that they've already put into place, a long time ago, as a matter of fact, and let them continue with the laws that they already have on the books. So that is what this First Amendment does, and I do want to add that it is based on the law that Texas has. So this is how Texas handled their non-discrimination statutes at the local level. So there's that one. Would you like me to do the second one, or do you want to mention to this one?
No, let's do it one at a time. Was a motion for an amendment? Is there a second? Second. We have a second from Leader Jones.
Can I speak to that, Mr.
Yes, author, you can respond.
Yeah, again, I would tell you this is, as I alluded to earlier, if we had passed a framework that Utah has, it would wipe clean all these local ordinances. Our bill does not do that. Our bill does not seek to wipe clean the 18 local ordinances that are in place. This bill would seek to have the state law we're passing yield to them in every circumstance. What our bill does, it's proposed, it's neutral. It doesn't strike them, doesn't wipe them clean, and it doesn't yield to them as the senator from the 42nd Amendment does. It simply stands next to them and allows the balancing test that RFRA is supposed to be. It allows our courts to weigh these interests, which in these 18 municipalities elevate certain interests, and we're fine with that. But allows free exercise to be given full weight as it should next to it and operate in parallel with it. That's the neutral bill we're seeking to propose. I think what this would do, Texas was one of the early adopters of RFRA, essentially gutted their RFRA bill, allowing locals to essentially trump it in every circumstance. I don't think that provides the kind of balance we're looking for, Mr. Chairman. I would respectfully oppose the amendment.
Yeah.
Let me put your mic back on.
Oh, thank you. I don't want to belabor the point at all, except to note that I don't agree with the gentleman's analysis of your own bill as protecting these local ordinances, which is why I'm offering it. But I respect your viewpoint.
All right. Any further discussion on the amendment? All those in favor of the amendment, please raise your hand. We have 3. All opposed, like sign. Still 7. Amendment fails. Other amendment?
Yes.
Senator Parent.
Thank you so much, Chairman Strickland. So this second amendment that I'd like to bring for the committee's consideration is AM 440209ER. And this is simply an anti-litem piece that's based on the way the federal RFRA is, and it would ensure that we were not dealing with a lot of frivolous lawsuits.
Do you have a copy of this one?
I do.
Okay. Your response from the author. Wait, is there a second for the amendment? Second from Leader Jones. Before we do that, you have, okay, the author, you want to respond?
Yeah, Mr. Chairman, appreciate the question. One of the things that RFRA does, and it's been proven its 32-year history, it actually eliminates lawsuits because it provides legal clarity. It provides a very clear standard of where protections are. The idea that this is going to create more litigation is simply not true, and it's not borne out in any of the 38 states that have RFRA. It candidly allows governments to come to the table. It prompts governments to come to the table to work with people, to work things out without having to go to court and having long litigation. I think this is, while theoretically I think perhaps it might sound good to the uninitiated, I think we see this is not going to have the effect that we need. And I think the balance we have, Governor Kemp, as he's leading on tort reform this year, his attorneys have supported the specific language in 2924ER because we've tried to strike that balance. The balance we need is in the original version. I would respectfully thank the lady for the sentiment, but don't think it's going to have the effect that she hopes it would.
All right. Any further discussion on the proposed amendment? All those in favor of the amendment, please raise your hand. 3. All opposed, like sign. Still 7. All right, amendment fails. Any other amendments? All right, back to the motion to pass. All those in favor of the motion, please raise your hand. Still 7. All opposed. Still 3. Motion carries. Thank you. Thank you, everybody that joined us today. With that, we are adjourned. Thank you.